Welcome once again to my channel. My name is Msimen Alex, and basically today I want to take us through land transactions, or what we call land law 2. Basically today we want to appreciate the plea of bona fide purchaser for value without notice. What should be proved and how actually one can qualify to be the bona fide purchaser for value without notice. The plea was actually defined in the case of Gatsinzi and another versus Rwanga Stephen, where court defined it as a common law doctrine that was set up, or that is set up against the allegations of fraud. That's very important. It's Gatsinzi and another versus Rwanga Stephen. It's a civil suit number 690 of 2005, wherein a court defined it as a common law doctrine that is set up against the allegations of fraud. That is very, very important. When we are talking about all this, we have to first appreciate the jurisprudence provided for under Section 59 of the Registration of Titles Act, far from or away from what we call the indefeasibility of a title. When we say that a title is not defeatable, where we say that a title is the conclusive evidence of ownership, where we bring now in the exceptions under Section 64, where we say that where there is an element of fraud, then a title cannot be looked at as a conclusive evidence of ownership, actually pursuant to Section 64 of the Registration of Titles Act. Ladies and gentlemen, I want to remind you that this provision brings it out very well, especially the provision under under 59, that a title is the conclusive evidence of ownership. That actually where your name, where the person's name is reflected on the title, on the certificate of title, then that person is the conclusive owner of that property. However, we now bring in, as I earlier mentioned, we bring in Section 64, where it says that where there is an element of fraud, then a person will not claim that his or her title is conclusive. But we need to know that pursuant to this doctrine, pursuant to the defense of the bona fide purchaser for value without notice, a person now brings it. Someone is alleging of fraud, but someone will come and say, no, I'm the bona fide purchaser for value without notice. You need to know that for one to qualify as the bona fide purchaser for value without notice, you must have carried out due diligence. You must have carried out, you must have exercised, you must have actually been cautious about the property or the land that you're buying. That's very, very important. You need to still, actually, when you read that case of Gatsinzi and another versus Rwanga Stephen, you will actually learn that when you buy land, yet you knew that, or you have it in your knowledge that the person who is occupying that land is not the vendor, then you cannot qualify as the bona fide purchaser for value without notice. You need to know that actually when you read the case of Haj Abdu Katende, Haj Abdu Nasa Katende versus Vitharidis Haridis and Company Limited, it's a civil suit number 84 of 2003. They will tell you that for one to qualify as a bona fide purchaser for value without notice, that person must be holding a title. That person must be in possession of the title to that effect. That is very important. The case brings it out very well that for you to qualify as the bona fide purchaser for value without notice, you must have carried out due diligence. You must have carried out due diligence. Still, the same case brings it out very well that for you to qualify as the bona fide purchaser for value without notice, you must be the holder of the title to that effect. It is important that actually when we talk about the issue that that means that when you successfully plead that defense, then your title cannot be defeated. As I earlier mentioned, with reference to the jurisprudence in the case of Gatsinzi and another, where it defines the doctrine as a defense that is set against the allegations of fraud. It means someone will not plead fraud because that defense will defeat that element of fraud, and you will still hold your title as the conclusive evidence of ownership. But it is important that you look at the case of Giovanni Katosa and the two others versus Fred Mbabazi civil appeal in the Court of Appeal, of course. It's number 125 of 2015, actually. That case brings it out very well that when a title is registered under RTA, then it cannot be defeated. That means when you actually, someone raises allegations of fraud and you had actually successfully carried out due diligence, you were the hold of, you had even the hold of the title, everything, then you qualify to hold your title as the conclusive evidence of ownership. That is very, very important. I wish to remind you that in the very case I earlier mentioned, in the very case of Gasinze and another versus Rwanga Stephen, court observed it very well that a person will not qualify as the bona fide purchaser if that person bought land and he knew that the occupier of that land is not the owner. I mentioned it very well. I had to repeat it so that actually for purposes of emphasis. If you buy land, but you well know that the person occupying that land is actually not the vendor, then you cannot qualify as the bona fide purchaser for value without notice. And when we actually drive deeply in the jurisprudence, in the case of Haji Nasa Katende, we shall learn that court actually observed that for one to qualify as the bona fide purchaser for value without notice, 7 things must be proved. 7 things must be proved. Number 1, that a person must be the holder of the certificate of title. Number 2, a person must have bought in good faith. Number 3, that a person must not have got notice of the fraud. 4, that a person must not be a party to the fraud. That is very important. And that a person must have bought or must have given in valuable consideration. And finally, that a person, the vendor, must have been in possession of that land at the time of selling. At that time when that land was sold, it was actually the vendor who was in possession. Prima facie, he was in possession, and then you qualify to be the bona fide purchaser for value without notice. The same jurisprudence was elucidated in the case of Sejak Nalima versus Rebecca Musoke. It's a Court of Appeal, civil appeal number 12 of 1985. The same principle was stated that for one to qualify as the bona fide purchaser for value without notice, you must prove the 7 things as I mentioned. It's a case of David Sejak Nalima versus Rebecca Musoke. Please take time and read that case. It brings it out very well, and it will actually guide you on, it will give us, it will shed more light on what we are basically meaning here. So I need to remind you that actually take you to jurisprudence in the case of, I mentioned the case of Gatsinza and another. That case, I trust it very well that it will bring out very well what we want. That the moment you appreciate it very well, then you can actually tell that this person is the bona fide purchaser or this person is not the bona fide purchaser. That is very important. And in that very case, as I earlier mentioned, they defined what amounts to bona fide purchaser for value without notice. I want to now remind you that actually take you to the decision in the case of Nabanova, Desranta, and another versus Chiawa Joseph and another. It's a High Court civil suit number 496 of 2005, where Justice Opio Aweli held that a person who purchases the state, who purchases the estate, knowing that the person in the occupation that actually the occupation of that estate is by another person. That's very important. That a person who purchases the estate, knowing that the person in occupation of that estate is actually not the vendor, then that person cannot qualify to be the bona fide purchaser for value without notice. I give you another decision that maybe will shed more light on that. Read a case of Frederick J.K. Zabwe versus Orient Bank. That case will give you more light. It actually defines what amounts to fraud. It refers to the jurisprudence, or it refers to the definition of fraud in Black's Law Dictionary, 6th edition at page 660. It defines fraud with reference to Black's Law. Take time, read that case. It is also a good jurisprudence with respect to bona fide purchaser for value without notice. Another jurisprudence that maybe will also shed light on that, you have to look at the case of Kampala Bottlers Limited versus the Manico Uganda Limited. It's a Supreme Court decision. It's number 22 of 1992. That case brings it also out very well. It actually defines fraud to mean a well-established fraud which is actual or some sort of dishonesty. That is very, very important. Please take time, appreciate the decisions in these cases that I've cited. Most especially these Supreme Court decisions, they bring out very well about that principle. I mentioned the case of Nasa Katende. I mentioned the case of David Sejaka versus Rebecca Msoke. I mentioned the case of Frederick Zabwe versus Orient Bank and 5 others. Please take time, read those cases. They will shed more light with respect to that plea of bona fide purchaser for value without notice. You will allow me to stop here for now, and I wish to remind you that please share with your friends. Please subscribe. We develop the art of learning together. Thank you so much.